Well, ladies and gentlemen, it's our pleasure to welcome you all back for a very special virtual lunch, the next in our virtual lunch series. And if you're joining us for the very first time, welcome. My name is Paul Jantz, your host for this afternoon. Now, firstly, before we get in today, and there's a number of you joining us today, and we've got a very, very high number of registrations, so we're looking forward to everyone joining us. Today is Are You OK Day. So first of all, and it's actually changed the little slogan a little bit. So it's actually, Are You Really OK? So do me a favor, if you've got the ability to reach out to some friends, to some mates, reach out and, make sure that they are okay. If you're in New South Wales, you're in Victoria, obviously we're going through a different stage than maybe what our guests are up in Brisbane, which I'll introduce you to Robert very shortly. But yeah, look, things are a little bit different and things, reach out, make sure people are okay. And I think that's a really, really important message that I wanted to share today before we got in today. Now, there's a fair few still coming in. So if you've just joined us, my name is Paul Jantz. Again, we started this educational series probably when, I'm going to laugh about it, when COVID first hit last year. It was an interesting stage where we had a number of different events planned. We decided to take those virtually. One of those things was our virtual lunch. So probably 18, 19 months ago was all about how we can bring various topics, various subjects, various speakers to the mix and share that with all of you. So today is going to take a slight little technical twist. So we're going to talk about testamentary and super proceeds trusts. And I've got a very special guest, Robert Lamb, who is next to us very soon. But just before I introduce Rob, and look, if you've got, it is a virtual lunch, so it'd be rude of me not to have my glass of wine with me. So please, if you want to grab a glass of wine, a beer, something more heavier, glass, or even a cup of tea, please join us with whatever you feel like joining us with. Now, just to give you a bit of an idea of the professional partners, because that's, look, I get hit up with all the time. While we're fantastic in bringing this educational series, we also get asked a lot about the professional partners. And this was a network, an accounting network that was pulled together by accountants at the time. And it's all about bringing a high-end service offering to your high-end clients, probably in the space of, call it the alternative asset space. It's something that a lot of accounting firms usually work with a financial planner, but they've got clients that ask for something a little bit alternative. If they've got their shared portfolio or they've got a property portfolio fairly locked in, but how are they going to increase their, let's say if they've got cash sitting there, and what other options do they have? And that's the sort of thing that we do. So if it's something you want to know more about, please hit me up after this lunch, because that's really important. But today we're going to talk to Hillhouse Legal, and I do have Robert Lamb there. Robert, how are you?
Good, thanks, Paul. How are you?
Good, mate. Sorry that was a bit of a long intro, but that's okay.
It's good to see everyone there. That's good.
Yeah, and obviously you guys are up in Brisbane, so not as in lockdown, a little bit more protected than us. How's life up in sunny Queensland?
We've been very fortunate as to my colleagues in Victoria and New South Wales. One of my colleagues in Victoria hasn't been out of his house for 8 months. It's extraordinary. Like, we are quite fortunate in Queensland. Sooner or later our turn will come probably, but yeah, we've been very lucky. So certainly feel for everyone down south. So yeah, hopefully Australia moves forward quickly enough, and next year we're all relatively back to normal.
That's exactly right. Let's hope we're not saying this.
No,
because we said this last year. So yes, it is a little bit crazy, but well, what do you do? What do you do? Mate, let's get into the topics that we're going to talk about today. We've got a lot of different firms that are joining us. So thank you again for all of you that have joined us. Hopefully we can instill a little bit of knowledge, education into some of the key things we're going to talk about. And in particular, we're going to talk about testamentary and super proceeds trusts. We're going to go into a little bit about detail what the trusts are, why you would need them, advantages, disadvantages. What are some of the horror stories as well that people like Robert and Hillhouse have actually experienced along the way? And we're even going to touch on, with time, we're going to touch on wills and the importance of wills. So we'll run through a fair bit over the next probably 40 minutes or so. So again, if you're joining us for the first time, thank you very much for being here. Rob, let's kick off with what is a testamentary trust? Let's probably start with the basics. Let's work through what is a testamentary trust, and then let's work through what's a super proceeds trust.
So, thank you, Paul. So, well, most people here are accountants, and there's nothing magical in the theory of a testamentary trust. Very basically, what it is it's a trust that comes into existence when the will is initiated, so when the person dies. That's what a testamentary trust is very basically. What it is in practice is what every accountant here will be familiar with. It's essentially a discretionary trust. So it's very similar thesis to a family discretionary trust, which I personally got, and I'm sure most of your clients have got, and it's often there for the same reason. So the set law or the appointor in a testamentary trust is the deceased. The trustee is usually their executor, but not necessarily. There are, depending on where the trust leads, particularly in cases of children, it can change from the executor to the child once they're grown up. And then the beneficiaries are probably the most important part, or important difference if you're thinking from a family trust point of view, in that it's a discretionary trust, as I say, but usually it's not as wide amount of beneficiaries as they would be in a family trust, because you want to ensure that the money or whatever's in the testamentary trust only goes to your children and usually their issue. So your grandchildren, the line. So it doesn't have to be that way, and obviously every wills can be different depending on the wishes of the deceased, the will maker. However, that's the usual proposition, that there's a trustee who's the executor and a discretionary trust for beneficiaries who are the deceased's line.
Okay. So before we move on to super proceeds trust, why would someone need a testamentary trust?
So the first step is when you see your clients, you work out what their circumstances are, and there's complete range of needs or requirements under a will. So very generically, there's two major needs or two major aspects why you would have a testamentary trust, and usually for the same reasons that you'd have a trust during life as well, a family discretionary trust, is for tax reasons and for asset protection reasons. So with a testamentary trust, the money coming into that trust, the capital coming into that trust, and then the earnings of that trust can be distributed to the different beneficiaries, who may well have, like they do in family trust during life, different marginal rates that the money can be put to different use, and within the realms of the law, the tax may be less than you'd pay if it was just given to one person.
Right. So
an example would be that a grandmother owns a unit in a body corporate. So I'll use the Gold Coast unit example, worth $1 million, but then also, say worth $500,000, and then generates an income of $50,000 a year. If she passed away and just left it to her daughter, who was a well-paid accountant earning in excess of $180,000, when her daughter sells that, when her daughter receives the income from that unit of $50,000 a year, she'll pay the top marginal rate on that income. Then when she sells the unit in 10 years' time and makes $500,000, subject to the appropriate deductions and cost base, she will then pay the top marginal rate on the capital gain. However, if that unit was passed through a testamentary trust, of which the daughter was a beneficiary, as well as the two grandchildren of the daughter, both who are under 18. And just a side note, at the moment, the law is that unlike a testamentary trust during life, you can distribute to beneficiaries under 18 and still take advantage of the tax-free marginal rate, whereas you get penalised in for a family trust during life. So in the scenario I just mentioned, the income would essentially be able to be split between the two infant beneficiaries. So they would probably pay $25,000 each. They would pay, I don't know the exact numbers, I'm not an accountant like everyone else in the audience, but the tax is probably maybe $1,000 or $2,000 each instead of $25,000.
Yes.
So you probably save $20,000 a year in tax. Then, when the property is sold, the capital gain of $500,000 will be able to be split at least 3 ways, and possibly even only 2 to those beneficiaries. And if say it was split 3 ways, well, say 2 ways because my maths is getting a bit.
I'm the same.
But, yeah, so even on 250 less the cost, $125,000 each,
yep.
They might pay $40,000 tax each. So $80,000 total tax instead of $250,000 or $125,000. So there's a lot of, for the sake of a testamentary trust will, that might cost a bit extra than a normal will, $2,000 or $3,000 extra.
Yes.
You could save literally $20,000, $30,000, $40,000 a year in tax for the income, and $100,000 when the property's sold. Now it's subject, of course, to the usual. The money has, you have your problems that when beneficiaries receive it, they actually have to receive it, tax returns and all that. But as we all know in this room, as long as everyone's complying with the law and everyone's doing the right thing, then the tax can be minimised within the realms of the law.
So some fairly massive benefits there.
That's right. That's the tax side. Yeah.
Yeah. There's always, I know in the early days when I used to work through things, it was always, what's the benefit of the benefit? We used to ask ourselves those type of questions. And when you look at it from that, I suppose that the key thing is how many people know about it and how many people don't know about it, and how many people could get stuck in that element of not knowing about it. And I suppose that's the purpose of today's lunch as well, is to share this. So the knowledge and the ability to start thinking like that, and maybe talking to clients about a testamentary trust.
That's right. And then, so that's one aspect of tax minimisation. Then the other reason that you have a testamentary trust is asset protection.
The asset protection side, yes.
So it's a little bit more nuanced than in a pure trust during life, but it's all about trying to ensure that the beneficiaries in the future, as well as the proceeds, the capital, the income and the capital of the trust, are protected from events that are sometimes within the will maker's control and sometimes without. So the will maker may be their second marriage, and they want to make sure that their children from their first marriage are looked after, but also their second wife is looked after, or second spouse, second spouse is looked after, and want to ensure the first spouse doesn't perhaps stick their head in where it isn't wanted. Or that in the future, one of their children, so it might, the will maker might have children in their teens, but they might be in their 60s and they might pass away for 25 years. But by that time, one of their children could be going through a divorce, or their children might be getting sued over a bad business deal, something like that. And if, for example, your son who's 35 years old when you pass away is going through a lawsuit, they won't suddenly want $1 million in their own name. That's going to be that's going to be a risk. So if they have the ability to put that money into a testamentary trust, then all things being equal, it's not going to form part of their bankrupt estate. So it's things like that. It's trying to protect as best you can within what is available under our system of law, within the realms of the law, to ensure that those sort of things are at least are an option for the person for the executor and the beneficiaries when it happens. So the wills that I do are all about options. It's all about giving the people at the time lots of options to do what is in their best interests, on advice from solicitors and accountants and financial planners as well.
Yes.
On what their circumstances are at the time and what their best options are at that time. It's all about flexibility.
Yeah, it's good. Look, some of the key things we've been talking about this year in particular, whether it be our Chewing the Accounting Fat shows or even our podcast, Talking Numbers, and certainly our virtual lunches throughout the year, has been getting a lot of our firms, all of you online, to actually start thinking about compliance is never going to die, but compliance is getting more and more and taking more and more up of your time.
Yes.
The ability to start getting out there and having conversations with clients and just chatting to them about these particular things, whether or not a testamentary trust would actually suit them for tax purposes and for asset protection purposes. There's some great things just to have a conversation, but not necessarily compliance driven. I think that's one of it's been a really nice little trend throughout the year now that we've been able to do that and do it quite successfully. So, which is really good, because I think, you know, the more that people see this as an opportunity and learn from these sorts of things, hopefully they're the sorts of conversations that firms like yourselves out there listening to this can actually start having with clients, I think, which is fairly important.
And that's right. So that's where I think your members, accountants, are so valuable, in that my job's made so much easier when I have an excellent rapport with the accountant who has the same with their clients. I get to know what their personal situation is, what their financial situation is, what their business situation is, through their accountants, through the clients, and you can develop a proper estate plan that has maximum flexibility for those particular people, particularly in today's, as you say, not so much it's complexity too, to some degree. It's the blended family scenario in our today's society.
Yep.
And also the rise in value of principal places of residence and houses and superannuation. So those things, the last generation, have become exponentially increased there. And to do a proper estate plan, you need to know all those things, people's quite intimate history, both financial and personal. And in the accountants, the rapport with the accountants is invaluable, because the accountants, your members, are going to be the first points of call.
100%.
When the second marriage happens, or the divorce happens, or the new business happens, or, you know, your self-managed super fund set up, it's you guys that they come and see. And there has to be something to spark. Have you guys thought about your estate plan? You've got a post office will you did back in 1997 when you didn't have any kids, and, you know, your house is worth $120,000. Now, you know, your super's worth $1 million, your house is worth $3 million, and you got a kid 17 and 25, and you're on your second marriage, and you've got a self-managed. It's the accountant going, oh, you know, have you thought about a new estate plan?
Correct.
So yeah, that's why it's so important. Just that trigger, just that, and your members are the point of call, because they hopefully only see me once or twice in a lifetime, but they'll be seeing everyone that I'm talking to once a year.
Correct. And I think that's the opportunity that exists, I think, for all of you that are online as accountants that are thinking about, you know, the type of people clients that you would be reaching out to talk to about this. That's just a pure opportunity.
Yes.
And they're working alongside a legal team like Hillhouse as an example. They can provide you that next layer of how does it all come together, but it's about the relationship, and 100%. And that's the great thing about the proactive firms that are out there at the moment. They're out there doing that and having those conversations, which is brilliant. Now let's talk about quickly about a super proceeds trust then. So let's sort of pivot towards there. Tell us a little bit about, again, what one is and why you would need it.
Yeah. So a super proceeds trust is not a superannuation fund. So don't think of it in the terms of a self-managed fund or just a normal fund. What it is is it's a vehicle, it's a trust within a will again. It's a form of testamentary trust designed just for superannuation proceeds. So once again, it's all about flexibility. So in the will, I will have the person can either take the money, like absolutely, take the money in a normal testamentary trust, or take the money in a superannuation proceeds trust, or parts of the money as well. And because, as we all know, if the superannuation is given to the wrong people, then tax will be payable on it. So it has to be given to the spouse, one of the children under 18, or a dependent child, usually a dependent person. Otherwise, it'll be a problem. But in the super proceeds trust, the beneficiaries of the trust are the requisite people. So once again, the executor, on advice, so from everyone watching, when they come and see you or me, we can say, look, if you give the money to this person, they'll be paying extra tax. So therefore, give it to the younger child, the superannuation. They get, say, $500,000 of superannuation. The other $500,000 from the sale of the house, for example, can go to another child in the testamentary trust.
Yep.
And in the wills, there's equalisation clauses. So if some tax is payable, if there is a capital asset sold and there's capital gains tax, and whatever the case may be, there's equalisation between those things. So it's once again just another mechanism to hold super proceeds in a tax effective way, because often you'll have children, one's grown up, one's not, or there will be a spouse and then adult children, second spouse and adult children, things like that.
Yeah.
And then also, as part of the estate plan, you do talk about people. Some people don't want things to go into their estate for some reason, usually a blended family reason. So you want to make sure that, subject to instructions, you may wish the superannuation to bypass the estate through binding nominations and things like that. So it's all about, once again, just all about flexibility, all about people on advice, talking to the executor, talking to the accountants, talking to the lawyers, and saying, this is what I can do. But you need someone, with all due humility, who knows what they're doing when they're doing that estate plan and drafting the documents to allow that to happen in 20, 30 years' time, hopefully. So it's all about that, someone who knows what they're doing on proper advice with the proper information. So yeah, so that's a super proceeds trust. Yeah, they're essentially a testamentary trust just to deal with the super proceeds.
Yeah,
and they may or may not receive money.
Yeah, and a good point there you just made as well. It's not a stock managed super fund as such.
No, it's not. No.
Trust, which is again. So let's dive a little bit deeper into that then, and say, well, what are some of the, let's call it, the advantages and disadvantages of having one, both, others? I know you've touched on from a testamentary point of view, and obviously there's a tax element there, plus an asset protection point of view. Any other disadvantages and advantages to super proceeds trust?
They're the same advantages per se. As I say, it's about flexibility. It's about that executor on advice being able to say, look, these are all the options I've got under the will. This is what I've got to do. This is what the estate consists of. The estate consists of some property coming out, some money coming from the UK, some the sale of a house, in the unit in the Gold Coast, the principal place of residence being sold, a death benefit from a super fund, the accumulation funds from a super fund, money from a self-managed super fund, and $100,000 in Commonwealth Bank shares and $100,000 in cash. And that all gets put on the table. And if you've got a simple will, you just have to sell everything, pay all the tax, and then give it to the beneficiaries. And God help them if they're going through a divorce or getting sued, plus you've just paid all this probably unnecessary tax.
Yes.
And if you've got the option of a testamentary trust and a super proceeds trust and equalisation clauses and in specie clauses where you can keep the Commonwealth Bank shares as a whole and don't have to sell them and pay, like Commonwealth Bank shares are $101 today, I think. You could buy them a year ago for $35. God knows what they were 20 years ago. Yeah, so you don't suddenly lose $70,000 in capital gains tax if you can. The person just keep them. They are pregnant with capital gains, but the beneficiary can keep them and see what happens and earn the income and pay the capital gains tax when it helps them. They might have a capital loss they can utilise. Who knows? Yep. So it's all about flexibility. And so instead of getting this big pile that you just have to give to the beneficiaries, you can deal with it and put it in effective ways, tax effective ways, asset protection, taking into account circumstances that may not even be known in 2021. It might be 2051 and your kids are both growing up and one's going through a divorce and one's getting sued, So, that's all about looking after your beneficiaries, being flexible, giving people options.
Yeah, brilliant. Given your experience, before we sort of move into wills and talk about wills, and by the way, the chat bar's going really well at the moment. I've got a couple of questions coming through as well, which is great. But the importance of, in these sort of times, certainly for New South Wales and Victoria as well, the importance of getting out there and just chatting to your clients. Have you got, given your experience, the importance of making sure you're doing that, checking in on people? What are their, I know there's a lot of mental health issues as well out there, but that then raises issues within the family, raises issues within the business. Are there some things in there that you could share as well?
Well, look, as a very general proposition, as I say, your members are so important in this regard. When someone comes and sees you, anyone really over 18, but really someone who's in business or got children under 18 and they haven't got a will, it's incumbent on us all to say they really should have a will. Now, I'm not trying to drum up business, of course, even though I am a little bit, but if you don't have a will, all that happens, it's like insurance. If you don't have it, all these dreadful consequences occur, all these unforeseen consequences and expense. And unlike insurance, so if you crash your car into the BMW and haven't got insurance, the worst that's going to happen is you're going to have to buy someone a new car.
Yep. If
you die without a will, not only will you probably pay a whole heap of unnecessary tax and whatever, the laws, the intestacy laws, so dying without a will is called intestate. The intestacy laws, whatever jurisdiction you're in, will determine what happens. And I've got a case at the moment where the people are in their 40s, and he died in a work accident. And they'd run a business, but they were both employees of the same company, a government company, and he died in an accident. And they have a house they own together. The house, unlike a lot of married couples who usually own their house jointly, so when you die, it automatically goes to your spouse. Because they'd been in business previously, they had the house separated as tenants in common.
Right.
It's unusual for married couples. But they didn't have a will, and they've got one daughter's 22 and one's 17. But under the Queensland intestacy laws, what happens if you've got children? So the first $150,000 goes to the spouse, and then the estate gets divided if you've got two children 3 ways. So this lady doesn't get to keep her house. She has, because her husband's part has to be divided 3 ways. So she has to find the money to pay the 2 daughters.
Yeah.
The husband, so 2/6 of the house.
Yes.
So 1/3 of the house, she has to mortgage to pay the daughters, 1/6 each. So that was an unintended consequence of her not having. And this is all going on when her husband's been unexpectedly, tragically killed. They're still husband and wife, perfectly happily married. So she's going through the grieving process, talking to lawyers, having to find a mortgage, dealing with 2 children who are also grieving, just because she didn't have a will that she probably could have done for $800.
Yes.
And it's that sort of thing that you go, well, it's so unnecessary. And as I say, it's like insurance, but insurance squared, because you're dealing with the grief as well.
Yes.
It's not a cold hard business thing with insurance. And then it can be even coupled with people fighting. So you might have, if you don't have a will, if you've got young children under 18 and you don't have a will, and you both, like mum and dad, die in a car accident, leaving their kids, you might have both sets of grandparents fighting it out in the family court over who gets guardianship of the kids.
Yes.
And just for the sake of not having a guardianship clause, having a will with a guardianship clause in it.
And it flows into exactly when I started this, because this is, again, while none of us really want to talk about it, we need to continue to shine the light. And again, in previous shows and podcasts that I've done as well, and it is Are You OK Day. So the suicide rates are something that no one talks about. It's something that, I know when we talk about mental health, and I've got a special guest talking about mental health very soon as well on one of our podcast shows. And it's really something that to start having that conversation with clients, because you don't know, as you said then, you don't know when that event will take place. And that's the dangerous part for a lot of people, whether they're married or unmarried or whatever it may be, where your estate may end up. And what's the worst possible? What happens with that if there's no will in place? And then we'll talk about some of the other, call it your post office will, and God knows why they still exist, but we'll talk about that as well. So again, we can start to help our viewers right now.
Well, look, certainly the lady's example there that I just explained is right up there with, you can imagine how horrible experience that is for her. Then I've just and also young people don't understand how those unintended consequences. So we had a case where the fellow, he was a single man in his late 20s. He'd been estranged from his father since he was a young child. His father left his mum and him, very close to his mum, and lived with his mum until he left home, and he was a FIFO worker. So I think he went to Western Australia, and he was in his 20s. I think he might have been 30, and he, I assume his mindset, like a lot of young people, I don't really have anything. Yes. I don't need to leave anything. I don't need a will. I don't got anything. I'm just got my motorbike, and I go to FIFO, and I just have a good time. What he didn't realise, didn't contemplate it. Once again, that's why if he'd been seeing his accountants raised it, or seen me and raised it, is that he had an accident at work and was killed. And there was a workers' compensation claim in Western Australia. Yeah. He had superannuation. He'd been working for 7 or 8 years for that company. The death benefit was the best part of $500,000. His accumulation fund was a couple of $100,000, or about 150,000. The workers' compensation claim was about $500,000. So he had $1 million up for grabs. And then what happened? Because he died without a will, so he didn't have any children. Yep. Under the Queensland intestacy laws, mum and dad are equal to 50% each. So dad comes out of the woodwork. Hadn't seen him for 25 years. He honestly wouldn't have wanted anything. He would not have wanted his dad to get anything. That would have been his on, and I believe his mother was my client. But but she had no choice. She had to do the right thing, and that was the intestacy. That's a hard and fast law, and it can't be deviated from. So his dad got $500,000 when it all sort of went to a mum. But for the sake, even a post office will probably would have done the trick. As awful as they are, it would have at least given it to his mum. He wouldn't have died without a will. So,
I think there's plenty of little stories like that. I often talk to a lot of firms, and things happen unexpectedly, and it's the furthest thing from your mind as well when things like that do happen. But it's about being proactive with that. So again, the opportunity for everyone listening to sort of tune into that and start having conversations with people around that. Do you have a will? And
look, even on Paul, even on
enduring
that,
power of attorney, these sort of things are so important.
Yeah, being proactive, like the proactive. So we had another case where the fellow had a will, but he'd done it before he had his kids. So, and I think he might have even done it. Yeah, so I think he'd done it. He was married to the lady, but he'd done it without his kids. And it was a really out-of-date will. And once again, just coincidentally, he was a FIFO worker as well. And he was driving back from work and he got killed. And, oh, that's right. Sorry, he had his executor. He'd done it before he married his wife, and his executor was someone who had since passed away. I think it might have even been his dad.
That's another good point, though, isn't it?
Away, yeah.
Yes.
So he hadn't updated his will, and his dad, since his dad passed away, the public trustee became his executor. And the public trustee, bless them, but for all their good qualities, one of their not so good qualities is they'll be very conservative and take a long time to do things. Meanwhile, his widow with 2 young children didn't have any money because for their particular circumstances, he sort of had everything in inverted commas, and she didn't know the bank, all the banks were in his name, and she didn't have a lot of access. She didn't have access to his money or his super or anything like that. And it took us about 12 months to work it out. We had to go in front of a judge, and the public trustee was very good and helped us, but they were just slow. Not being critical, they were just slow.
Yeah.
This lady in the meantime is looking after 2 kids with no money. And it was she was entitled to it. It was lawfully hers. It just took, because the executor was not someone he contemplated, and he hadn't updated his will. So he had a will that just didn't work for his situation. So once again, if he'd seen his accountant, or if he hadn't, his accountant had to mention, have you got an updated will? And he says, I did my will, back in 1988. Then, well, perhaps you should, So once again, you just trigger that question. Have you thought about it? Have you done it? And
I think that's an important point. So, to everyone that's listening, not only, and I'm sure this isn't, this is not rocket science, but this is something that I suppose for everyone to get out there and talk to their clients about. One, and if I talk from my own personal experience, I've got 3 boys. So circumstances change, which is exactly what you mentioned before.
Yeah.
You have one, then you have another, then you have another. Then unfortunately, I got divorced as well. So there's another trigger event where things need to be changed as well. Yeah. The executor, I never thought about that one, but you're right. There's another trigger event where if the executor is a family member and that family member passes.
Yes.
Well, so things, how often should you look at updating your will or having that conversation?
Well, look, officially I'd sort of say in the absence of being a major life event like marriage, divorce, birth of a child, business, setting up business, setting up self-managed super fund, becoming, like self-employed perhaps, or self-employed, something like that should certainly trigger it. Otherwise, it's usually every about 5 years you sort of think about it. But really, once again, it's the accountants, it's your members that people see. It's that once a year touch point, just someone raising, have you got a will? Have you thought about it? Have you circled? Because the accountant knows. You guys will know if you set up the self-managed super fund, you're setting up a corporate trustee for the family trust because they've just bought a cafe, or, they've come and seen you because they're getting divorced and need some information for the family court, or, things like that should trigger. And one good thing about my wills is, as a general rule, providing they're the testamentary trust wills, the more complicated ones, the sort of 7 out of 10 between about 3 and 7 out of 10 complicated ones, they're pretty future-proof. In the absence of a divorce and setting up a self-managed super fund, if you haven't got one at the time I do the will, in the absence of those sort of things, they contemplate future children, and because of that flexibility, they contemplate most circumstances. So they are reasonably future-proof. So unlike insurance, you don't have to pay your premium every year. You pay it the once, and then usually, in the absence of a major life event, it's pretty good. But once again, it's the touchstone with your members. They're the ones who probably just need to say the responsibility of, I suppose, for want of a better word, without incurring any legal responsibility, the lawyer in me saying it, but
couldn't agree more.
That trigger, yeah.
Couldn't agree more. And just the one thing to touch on for everyone that's listening to this as well is it's a bit like the "Are you okay?" Are you okay?
Yeah.
And most people would say, yeah, I'm pretty good.
Yeah.
Are you really okay? So don't just. There's a lot of times where I see it, and I've seen it with working with an accountant or accounting firm for so long now. It's a bit of a checklist. Do you have a will? Well, you've got to ask the next question, because that person may say yes, but when's the last time you reviewed it?
That's right. When have you last done it, and have things changed? That's right.
Have things changed? And they're the trigger events that we're talking about. So don't just go off a little checklist and tick, tick, tick. Ask the deeper question, which means that will provoke a different type of response, a different type of communication, and more importantly, it's the care factor. You're not trying to sell them anything; you're trying to protect them. That's the key thing here. Yeah,
no, that's right. That's right. It's really, it's just one of those things, and it's not a pleasant conversation.
No,
it's well, sorry, the topic isn't a pleasant conversation, and it's money you spend. You don't necessarily see the benefit of yourself, but it's certainly, I can know through bitter professional experience that without one, all you're doing is causing your loved ones who are already in a stage of grief and anxiety, far more grief and anxiety, and a much, much larger lawyer's bill.
Spot on. And it's stuff you don't really want to deal with. You're like you said before, you're going through that emotional state of grieving. It's the last thing you want to do is deal with this.
It's horrible. If you may have to give evidence in the Supreme Court witness box in front of a Supreme Court judge about why the will should be, why the estate should be handled a certain way, while your loved ones, it's horrible. It's horrible.
I can imagine. Yeah. Can imagine. Mate, I've got a question here coming through from Albert. Albert's spoken about he had a will created in WA, and the will and the laws over to Victoria. Would that still be something that stacks up over in Western Australia?
Certainly, and with all due respect to our friends over in the West, who might see Mr. McGowan might
country over there,
make the border permanent. You do have to be a little bit. So Western Australia is quite a unique example in that they do have quite different laws. Yeah, well, you have to be very careful as a lawyer. You have to read. Don't assume anything's the same in WA, I'll put it that way. It does, on a case-by-case basis, it certainly has to get taken into account. As a general rule, Australia's pretty good because our laws are fairly uniform. We don't have a state tax. And then so it's usually doesn't matter too much. But depending on what the issues are in the estate, you might be trying to be a little bit within the realms of the law again, creative about what jurisdiction you get probate in or letters of administration, which are usually dictated by where the person died or where the assets are. But it doesn't have to be, and but it usually doesn't matter too much in Australia. It's usually sometimes whether or not you need probate can matter. Like in Queensland, you don't need probate for real property, for houses.
Yes.
Whereas in most other states you do to transfer the house, but in Queensland you don't. But most times the nursing homes will want probate anyway, or if banks, let's say with $50,000 or $100,000 in the bank account, they want probate. So that might be the only other consideration, is if you can get it in Queensland. If the property's in a state that needs probate, that's probably where you go for probate.
Yeah, fair call. No, we're just coming on to 45 minutes now. Just as a quick one before we look to wrap up, If anyone's got questions, they want to reach out to you, what's the best way to reach out?
Yeah, so thank you. So we're in Queensland, but certainly I'm a litigator by trade, and I've litigated everywhere in the east coast of Australia, even Western Australia. I think, yes, I have in Western Australia once or twice. But we're Queensland based, but certainly can assist anyone in New South Wales and Victoria as well. At the moment, it's a little bit complicated with signing, but not insurmountable. And I've got fellow colleagues in New South Wales and Victoria that I help, and vice versa, with signing and things like that. My email is robert@hillhouse.com.au. Telephone 0418 757 458. Happy to talk. If anyone's got any questions about this, Hillhouse do just about every type of business and commercial law. Probably the only things we don't do are criminal law and immigration, but most other things we can do. I do employment law as well. So yeah.
And also fair to say you work with a number of accounting firms right now.
Indeed, we will work with major accounting firms and a lot of smaller accounting firms, 1 and 2 people directors. We pride ourselves in being very responsive. I pride myself in, if someone wants to pick up the phone and ring me, I'll talk to them. There's no charge, there's no obligation. I'll do my best to help them and go from there. We value our referrers, we value our relationships with people like you, Paul. But it's all about getting out there, just helping your clients, as you say, making sure they're okay, really are okay.
Yes.
And wills and estates is a useful tool. It's a positive influence. It's a step. It's something everyone really should have. Really, unless there's really no good reason not to have one, to be brutally honest.
100%. Well, mate, thank you very much. Check out Robert Lamb on LinkedIn.
Yes, and on LinkedIn, and Zach Herps too, my managing director down the bottom there. We're both on LinkedIn, so please feel free to send an invitation and check us out.
Magnificent, mate. Thank you very much. Look, to all of you that have joined us, thanks. Look out for our Chewing the Accounting Fat. I sometimes get that wrong, but it's great being live when you're going chewing the cat. It's not a cat. It's Chewing the Accounting Fat with my co-host Jason Cunningham. We are coming to you next week. We are talking about how do we make accounting sexy. This is an interesting topic for us, and there's a lot of accounting firms like you guys out there right now that we're looking at it from a resourcing point of view, from a capacity point of view, from a people point of view, and we're going to be raising some interesting topics around how do you grow if you haven't got capacity. People are hard to find. Good people are even harder to find. The borders are closed. I feel it's going to be a problem in the future, and accounting firms are telling me that as well. Without capacity, it's very difficult to grow. So we're going to be breaking that down and looking at how we can actually make accounting sexier for school leavers as well. And what do we need to do to start changing that for school leavers, rather than most people going into technology as an example, and most don't want to go into accounting and commerce. But we're going to break that down. So look out for that invitation as well. Robert, please pass on a thank you as well to Zach. It's very much appreciated. Your time's been very, very well appreciated. And yeah, if anyone has got questions, in-depth questions, check out Robert or send him an email or give him a call. So, thanks, mate.
Thanks, Paul.
And I look forward to talking to you soon.
Thanks
everyone.
Bye.